I saw Mr. Esau. Good morning.
Good morning, Your Honor.
And I did receive a pile of papers here. And I was just looking through those. Did everybody get a copy of those?
I believe they did, Your Honor. We sent out an initial copy yesterday morning, and then we updated it after the court visitor made some recommendations, and I sent it out again this morning. So,
I
Okay.
didn't receive a copy of the new one. I got the one yesterday, but not the one from this morning.
okay.
All right. So
I could tell you what the change is. It's just we just added one paragraph about it was contained in the Ms. Day's report on page 5, and it said that mother commits to provide all transportation for any activities or events that Marley has committed to participating in and to be on time. If mother is late 2 or more times to the event or activity, visitation should be adjusted to have petitioner provide for Marley's timely attendance at activities, and the exchange for visitation with mother would be adjusted to occur after the event. So that was the portion that was added from the first draft I sent out.
Okay, thank you.
is that's on page 7, looks like?
I believe so. Yeah.
And I believe that is what was agreed to.
Okay. All right. Ms. Day, have you seen this order?
Yes, Your Honor, I have, and I agree that it's accurate to what the agreement is and reflects the changes that were discussed.
Okay. All right. With that change, Ms. Rowland, is that agreeable to you as well?
Yes.
Okay. Very good. I did also, I'm approving Mr. Esau's fees as is requested. Those are in the order. Those are paid by the county.
Thank you.
So today is the 23rd.
And my fees are included as well, Your Honor, but I also have to submit a separate order, which I will forward to you later today.
I see that. Okay, they are there. Yep, correct. Very good. All right, so I've approved all those orders. So that is in place. That'll go out to my clerk right after this docket. Like, Ms. Day, you're involved in the Hicks
Thank you, Your
matter.
Honor.
Thank you, Your Honor.
Thank you.
Yes, I am, Your Honor.
I think we were waiting for Mr. Agnosti to do some sort of briefing on the party status of his client. I don't have anything. Have you seen anything?
No, and I don't believe he's filed anything. So we are set for a readiness coming up and a evidentiary hearing. So if he hasn't filed it, there'll be no response and we'll be able to move forward because the alleged father he's not disposed as the father yet.
Okay. All right. So yeah, it looks like we're set for readiness on the 30th and fact finding or hearing on the 5th. So I think that's proper to move forward unless there's something he finds legally otherwise. I think it's the same position I've taken with dependency matters and unproven fathers. So
yes, and that's been my experience consistently, not only in our county but in Lewis and Clark as well.
Okay, so we'll just leave it on for readiness on the 30th, and that's at 11:30 in the morning, with an expected hearing date on the 5th.
Her
All right, thank you, sir.
temporary guardian.
You're welcome. Thank you. Good morning.
Good morning.
And Ms. Farr, I think we were here previously.
Good morning.
I have a consent in the file that was filed on the 8th from the mother, I believe.
Yes.
Okay. And was this one where we had the father not on the birth certificate?
No, I'm sorry.
Go ahead.
So the father the father has signed a POA over to his mother. I haven't spoke to the father yet. I still need to speak with the mother as well. I don't believe the mother can consent with a POA to a guardianship.
I would agree.
Is that okay?
I would think that he would need to sign an actual joinder or something like that.
So I need to speak with the father directly, and that's where I'm at with that. I just need a little bit more time to get in touch with the father.
Okay. How much time would you like to set this?
Probably a couple weeks. I should be able to reach out to him this week.
Let me just check something. So we're under, so if we extend this out, do you want to go the 6th or the 13th?
The 6th would work better for me, Mrs. Farr.
That's fine.
Okay, so we'll set it on for 10:30 on the 6th of February. I'll do a new order after court, extending out the temporary to that point. No other changes, and then we'll see where we're at.
Thank you.
Thank you. I appreciate your guys' time.
So Yeah, no we problem. just Thank you. addressed
Bye-bye.
the one matter that you were going to do some briefing on, because I haven't seen any briefing. I just left it on for readiness at this point.
Yes, Your Honor, I have done some legal research and found a case supporting leaving my client in this case. If you want to get the site, I can give it to you. I'll tell you what it's about. It's in-ray dependency of NG. It's at 510 Pacific 3rd, 335. And in-ray, the dependency of NG, a third party intervened into a dependency action, and the court granted that, it's interesting in that what the court was talking about was whether an intervention substantially alters a status quo inside the litigation, and the court found that allowing a third party in a dependency case who was not a father, he was not biological, was appropriate in dependency cases. So what we have in this case is my client was served and he was named, and he believes he is the father of the child, and we're in the process of getting the DNA testing done. Unfortunately, he's been incarcerated, so not able to exercise any kind of visitation rights through this process. But because he was served, he wouldn't need to bring a motion to intervene to be in the case. I could do that if the court wants it and wants facts as to why he's the presumed father, or at least why he's involved in this case at this point. But that's the legal research that I found. So it would be a motion for permissive intervention. The court can allow that. It's not needed in this case because he was served and has been, a party to this action.
Okay.
And this was
So
a
if I could
Well-
jump in here, Your Honor.
right.
Go
Just
ahead.
one more thing. It's just that this is a 2022 case. And they talked about cases because the general rule is that they don't allow intervention in dependency cases. So sorry about that. I didn't mean to interrupt. Go ahead, counsel.
That's okay. It's Tina Day, the guardian ad litem.
Oh, okay. I thought.
That's okay. There are no other attorneys in this case, and I guess I'm a little bit concerned about. I'm not an attorney, so I can't speak to any of this, but my experience has been very different than that. Just as it has been in dependency, as it is in minor guardianships. Until they're established as the father, they don't have standing. And that is every case across the board that I have in all three counties. And it is what I've heard from every other court visitor and guardian ad litem involved in minor guardianship. I'm not opposed to the father becoming involved once he has established paternity. Obviously, I think that's the proper and appropriate thing to do. I believe that he had plenty of opportunity to do that when he was not incarcerated, and that he chose not to take those steps and appear or be present and participate in this matter in a way that would have given him parental place in this case. He has not done that. He is incarcerated for an extended period of time, and regardless of his place in this case, this child needs and deserves an opportunity to be safe and stable in a home without further delay. And this case has been delayed for an extended period of time for a person who has not even bothered to finish the basic thing that could have been done when he was out. Every other case I have does not allow him to participate until he's a father. I think he should follow through with those steps. And once he has, then he can be admitted into the case and seek whatever legal remedies he finds appropriate.
Mr. Ignastu, do you know his anticipated release date at this point?
I believe I would have to check again, but my last recollection was that it was going to be in the spring, sometime in the spring of this year.
Your Honor, I may be able to assist with that. The most recent expected release date the state has is January of 2025.
Oh,
Okay. So I guess my thought on this would be, I guess as follows. First off, there's nothing that's stopping your client from proceeding ahead to establish paternity. Obviously, that everybody would have to participate in that if that's what his goal is. He's not going to be, it sounds like, and again, I don't have all those facts, I'm just based on what I've heard today, he's not going to be in a position really to contest the guardianship until his release date, at least on his own behalf. So my
And
thought
if I
is,
could comment on that, Your Honor, just, I hate
Well-
to interrupt, but his recent date from his most recent conviction is 27 months.
okay. Well, what I'm thinking is if he wants to proceed along and establish paternity, he certainly can petition into the case. He would be a party at that point because then we'd have to address any issues as far as visits or anything else at that point. I don't know that moving ahead without him as an active party, because I don't think I can order any kind of visitation until he's established, and that's at least my position in dependencies, and that issue is currently up at the Court of Appeals right now. I know, and I think we're all anxiously awaiting the outcome of that. I think I'm correct on that, but once he establishes, then we can move forward with whatever other relief may need to be addressed. This wouldn't compromise that. But if he's not going to be released in the next 6 months, then the child needs to be someplace.
No, well, I don't disagree with that.
Yeah, and I wouldn't have any issue of putting in some sort of reservation should he determine that he's father, that he would be able to come before the court and ask for relief, and we would address it, of course.
Sure.
So I think where that leaves us today, and I haven't read this case, but I will read that case. I don't know that changes the circumstances, and the dependency is a little bit different. I don't know if the intervener in that case was somebody incarcerated or somebody who was not incarcerated, because that actually makes some bit of a difference.
The intervener claimed to be not a parent, but a kind of substitute parent.
Okay.
I always get confused about that language.
All right. And were they incarcerated?
No,
Okay.
no. The intervener sought the parent in that case was in a dependency action, and the intervener stepped in and said, "I want custody of NG because I have a relationship with him." And the court allowed him to have permissive intervention, and then it went up on the Court of Appeals, and they said that can happen. And the general rule is it shouldn't for non-parents, but they allowed it because of the relationship and other factors.
Okay. So I would assume that's coming under and I forget it's been a while since I've looked at that, but there's the doctrine where you're acting as a parent, and
Right. Right. That's the same word I was trying to come up with.
and it's escaping me, but that's not unusual. So I think what I'm going to do, I'm going to leave it on to move ahead. And we'll assume we're going to have a hearing in early February with a readiness on the 30th. Was it the 30th that was the readiness, Ms. Day?
Yes, Your Honor.
Okay.
Yeah.
And also, Your Honor, just as a reminder, we do have an open parentage case for Mr. McKnight regarding this child through the state. So we are in the process of getting those appointments set up for genetic testing. So he will know in the near future whether or not he is the legal father of the child.
Yeah, and I think once we get to that point, well, we can revisit this and determine what adjustments, if any, need to be made to the orders. So I'm going to leave it on for readiness, and we'll plan on a hearing on the 5th.
Thank you.
Thank you, Your Honor.
Okay.
Thanks, Your Honor.
Welcome.
Well, and I looked it up. It's de facto parentage.
De facto, that's the word. Thank you. It was not coming to my mind,
Right.
and I've
Me neither.
not seen orders on this unless I am missing something.
You are not. Since our last hearing, I got very sick and was out of my office.
No.
And, when I got back into the office, it was after the snowstorm, so I was out for an additional 3 days because of that. And
Okay.
it was a holiday, so and then I was in trial all day on Friday, so I did not get the order prepared, Your Honor. I apologize.
All right. How much time do you think you need to get get that done?
You know, I should be able to get it out this week, so 2 weeks.
2 weeks. So
I
that
can
would
get it
also
to-
be. So we'll put this onto the 6th. I'll extend the order that far as well.
Okay.
That was Winchester. That is not an issue, so we'll get that taken care of. Is anyone else appearing on that matter today?
I
Thank
am,
you.
Your Honor, as the court visitor. I don't think the petitioner is here. But
Okay.
I will check with her and I know she will sign off on the orders once they're prepared.
Okay. So we'll assume we'll have that ready to go and we'll come back on the 6th to get that entered. 7:08.
Okay, very good, Your Honor.
Thank you.
And thank you. Ms. Farr, I think you're involved in this one.
Yes.
And do I have anybody else here on this matter?
I'm the mother.
Ah, there we go. Good morning. All right. So let me see here. This was one where I have there's an Oregon birth certificate that was filed that does not list a father
Correct.
No.
on the birth certificate. So where are we at on this one then, Ms. Farr?
And so in this one, the father is also incarcerated, and as well as not being listed on the birth certificate. But the mother, the affidavit of service on the mother is signed by the petitioner, so that's not proper service.
Okay.
And I have not been able to contact. I haven't talked with either the mother or the petitioner yet.
Okay. So speaking to the mother, and that's it's Rachel?
Yes.
Okay,
Yes.
good morning. So did you receive some papers in this case? I assume you did since you're here.
Yes. She when she brought Ambrose over for a visit, she served the papers. I have screenshots of all of it. I was served. We've been waiting on this for a while. I'm voluntarily giving custody to her.
Okay.
Oh, okay.
Yeah.
Okay. So based on your statement today, I will make a finding that you've either accepted service or that we have proper service, so we can move forward on that issue. What will need to happen in this case is Ms. Farr will need to speak with both of you, just because that's how this process works. There's
Okay.
there's an order of things in these cases, and so she'll need to speak with both of you and put together a report for us. And if everybody's in agreement, we can probably just do an agreed order at that point. Ms. Farr, what's your timelines at this juncture?
I could do this one in a couple of weeks too, if I can reach out to mother. Mother, if you could give me your phone number.
Yeah, it's 971.
So I can reach out to mother and send her a consent form to sign and interview her, and then we can go forward. So
Okay.
probably, I would say,
You want to go the 6th, or do you want to go a week farther?
if we could do the 13th, just to give me, not so I don't double up on my reports here.
I think that makes sense. So I'll do an order extending with no other changes out to the 13th of February at 10:30, and
Okay.
all goes according to plan. We may be able to do an order at that point with any luck.
All right.
Thank you.
All right. Thank you.
All right, very good. And I
Right.
believe, do we have anyone else here who's expecting something this morning? I don't have anything on my docket left, so I think that is it. See, Ms. Winkles is present. Is anybody here on behalf of Mr. Mean?
And I've received no response, Your Honor.
Have not either. This looks like this was also substitute service on this one, if I recall.
We have substitute service on Mr. Mean at his parents' house, which it appears he now lives. We also did service on his girlfriend's house in Vancouver and also mailed all the filings to both places as well.
I guess my concern on this one is this was just, and I know there's an order shortening time, but this was served, 3 days ago. And I understand I don't have a response, but normally they'd have 25 days to respond to something like this, and that's concerning.
And we don't mind setting it over. Our only concern was this was one that where there was quite a lot of domestic violence, and we missed. Normally we'd go 90 days before it expired. We didn't do that in this case because my client wasn't my client anymore, frankly. I don't mind setting it over and giving him a chance to respond as long as the original restraining order is still in place until he gets the chance to respond. The concern was just having any sort of gap in protection.
No, and I understand that. My thought would be is I'm not sure when the other one expired. Did we extend it on a temporary? Let me see here. So I'm assuming it expires February 14th.
That sounds right. Unfortunately, we're having computer issues, which is why I'm in the front of my office right now. I am having my legal assistant look.
I'm just looking right now. So yeah, it looks like this was signed February 14th of 2022. That's strange. It says it ends January 31st.
And that was the issue that we found as well.
That's odd. Okay, so what I'm going to do on this one, I'm going to set it over 1 week to the 30th. See if there's any response. If there isn't, then I'll grant your orders.
There's no.
Okay, that sounds
Oh,
good.
there is no grant on the 30th. Would you be able to provide an extension order that would get us to the 6th?
Absolutely.
Okay, if you could just do an order extending the restraining order to the 6th, I'll set it over to the 6th. And if we don't have some sort of response at that point, I'll grant the request as in the motion.
All right, thank you.
So the problem on this one was just served last Thursday. And normally it's 25 days or 21 days lead time for a motion like this.
Okay, he knew that it was coming. He was also aware of it. It was emailed to him prior to it being dropped off at our son's house. This is timely. My home's going to be up for foreclosure on the 5th of February.
Okay. All right, so just a second. All right, and do you have any response to this, sir?
There's just no way that I can, I signed a quitclaim deed, so I can't get a loan for the house. I'm not sure what Ms. Fitzpatrick wants other than a new roof and a kitchen put in her house, but legally there's nothing that I can do because I don't own the house. Nobody will, I've tried to get a loan for it and nobody will loan me money. So if she could refinance it and I could still make the mandatory payments of $262 a week, I mean, that would be.
Your Honor, the deed hasn't actually been transferred. He needs to sign an excise tax form and he's refused to sign it. So it is technically still in his name.
I have went to my bank.
So the problem is that the order requires him to make the monthly payment. It doesn't require a refinance that I could see in the order. It just says you're supposed to make the payment.
On that mortgage.
Correct.
I can't refinance it, which is why the judge set it up the way that it was. I don't have the funds. I have tried twice. I have the documentation here that
I'm not questioning that. He's not in contempt of the order as far as I can see, as long as he keeps making the monthly payment.
So the house is going to be foreclosed on.
I understand that, but that's not what your court order says, which is different than a contempt motion.
Okay, so what does that mean for me then?
Have you talked with your attorneys to set this up?
I didn't have an attorney.
I have talked to an attorney, and she said that if no banking institution will refinance, that's as far as I can go with it.
I have offered to reach out to Mr. Harrison to establish some sort of legal ownership for him, and I at the same time to protect my interest in the property and allow him to get a mortgage.
Well, I've reviewed through the decree. Let me just a second and see if I missed something here.
It does state at the end, I'm not required to refinance it until after the end of the term.
Well, all I know is what the court order says, that he's to make payments of $262 every week or $1135 a month from April 1st of 2021 through March 31st of 2030. And then it looks like you were going to take over the payment at that time.
I was under the impression that I said at the end that I had 90 days to attempt to get a loan on the property. It's like the last paragraph of the filing.
Well, it's unclear the way this order is written.
And unfortunately, neither Mr. Harrison nor his attorney disclosed this balloon payment at the time that we were in court originally. Otherwise, this would have been addressed at that time.
Well, at this juncture, I would suggest you see if you can talk with an attorney. There's not much I can do on this. As long as he's making that payment weekly.
So he's going to continue to pay the credit union, which is what it said he has to do. He has to pay it to
Correct.
that credit union that's going to foreclose on my house. Because that's their intention, is to foreclose on the 5th.
I understand, but he's only required to do what the court order tells him to do.
Okay, how do I amend the court order?
Well, you'd have to file a motion to do that or something to do that. I would suggest you probably need to get some legal advice rather quickly, obviously. Is there a foreclosure sale going on, or?
No, it's not that far. I just got the first paperwork.
He was issued a demand letter.
2 weeks ago.
Okay.
So it's still a ways out before they're gonna do, I guess, the next step.
Okay, so again, I can't make a finding of contempt based on the order, which he's doing what the order says. There's nothing in here that says it has to be a balloon payment or a refinance or anything like that. It just says he's supposed to do what he's supposed to do.
Okay, can we ask him if he's made the payment for December? Because it's my opinion, it's my understanding that they've stopped accepting payment. So
I don't know. Have you made the payments?
They are continuing to, it's a direct deposit.
Okay.
So they're taking it out and still making the payment. It's just the balloon is matured, and that's what needs to be taken care of.
So what I would suggest maybe the two of you do is go down there and talk to them, see what they're willing to do within whatever parameters they're able to do that keeps you in compliance with this, making those payments for that period.
They also informed me that, or I asked them if they would still take out the 260.
Otherwise, I would have brought Dottie with me.
They do whatever they do on their end, still take it out, the 262, so I'm not in contempt. And they will either put it in her account or.
Well, what I'm saying is if this thing goes sideways, I don't know what that's going to ultimately result in, but it could end up with a result of coming back and have some modification to this. So what I'd suggest is maybe the two of you together talk with the credit union, see if they're willing to work out something that can get this taken care of. I can't make a contempt finding as long as he's still having those payments to go to the credit union. And the order as it sits doesn't require him to do a balloon payment refinance. It just says he's supposed to make a monthly payment until 2030. So again, I would suggest you get some legal advice. If you're at this juncture in the foreclosure process, then you've got a bit of time, probably, I don't know, at least a month or two. But I would suggest getting some assistance as soon as possible to see what can be done to do this. But there's nothing I can do at this juncture as long as those payments are still being made.
okay, and I have one further question. If I have to sell my house due to this, is he going to be required to pay those payments continually for that term? Or is he just going to not have to pay it?
No, he's supposed to make the payments for that period of time. I mean, it's the court order is what it is. It's not changing any. So the requirement's still there.
All right, thank you.
Okay, but again, I would suggest you both get some legal advice sooner than later. Okay,
Thank you, sir.
looks like there's two motions, one for motion to compel and one on a temporary order change. So counsel, who would like to address that first?
Yes, Your Honor. Counsel and I had previously talked about setting this over as he was supposed to be in trial at this time, so I'm asking to set it over, but I would request that we have a rather short set over date just because this has been put on for so long, and to be frank with the court, as well as Mr. Gross, I have talked to him. Our next steps are going to be filing a motion for default on this as opposing party has basically not responded to anything.
Okay, so what are you asking me to do today?
So I'm asking to set over today, but I'm asking for a set over date that is as close as possible.
That would be the 6th of February.
Okay.
Mr. Gross, is that
I'm checking my calendar as we speak, Your Honor. And that's just fine. Thank you very much.
Okay, so we'll set it over to 1 o'clock on the 6th of February.
Understood.
Thank you, Your Honor.
Thank you. Thank you, counsel.
Thank you, Mr. Gross.
Yeah, go ahead and have a seat there at the table, sir. And you're Patrick Phillips?
Yes, sir.
Okay. And I see Miss Cotto is there.
Your Honor, this is Amy Trimble, the guardian ad litem on the case.
Okay. So I'm not sure why this is on today. It was set over from a motion that was not granted, and then it was just set on for something. There's no paperwork in the file, so.
And I have to note it on in front of Judge Fassett to get the order entered, but it was on to review the guardian ad litem. This is kind of a unique case that involves, it's not, this is a high needs, high maintenance child. And so there's a number of experts to talk to. And I know that Ms. Turnfield's been working on it, but also Mr. Phillips was supposed to sign ROIs, including me. And my phone calls have been that I made a call just recently that I'm not part of the ROI, did not include me, but just to basically review the case, see where we are at. And I need to find out from Mr. Phillips if he is doing his, if he's got an anger and evaluation and where it was at. I don't think we're really ready to go forward. And I think the guardian can speak to it better than I can, but there's still some experts and some folks that need to be talked to before we start looking at Mr. Phillips' visitation.
Ms. Turnbull?
I would agree with that. Mr. Phillips is in the process. He has done his abuse evaluation and a mental health evaluation, but those have not yet been collateralized. We're working on getting that done. There's been some miscommunication on that. He has not yet done the anger management assessment, and he has some questions for you about that today that he'd like to address. He also has some questions about the release of information for Ms. Cotto that he'd like to address. I've asked him to sign the release of information for Ms. Cotto. I just spoke with him earlier today. Apparently he has not yet done that and has some concerns about it. But my understanding is he has signed the ROIs for Ms. Mayer and myself. So we do need to complete that collateralization and complete those 3 assessments before we can move forward. I do have some other experts that I do need to speak to, and healthcare providers for the child in particular before we move forward as well.
Okay. Like I said, this isn't on, as far as I can see, for any issue for the court to address. Is why I'm trying to understand why we're here today.
It was on for review just to see where we were at with the experts and the GAL. And I can tell the court that there's about, I think, 4 or 5 experts that are treating the child, school folks. And so I think it was on just to see where we were at and if we're making forward progress, because the court wanted us to do some forward progress, but we've kind of hit the wall on a few things. So I don't know if the court wants something in writing from all the parties, or you want to hear. I have no idea what the problem is or what Mr. Phillips's concerns are about signing an ROI for me. I just know it wasn't done, and it was ordered.
When would, well, hold on a second. When was that ordered? Because
that was ordered back in the last time we were before the court. I'm looking for my notes. I don't have it exactly in front of me. I've got the order that I finished, and it was in front of Judge Fassett, and she did order that he sign ROIs for me. I don't have a problem adding to that order that I'm not to disseminate the information other than to talk to my client and the experts, if that's what Mr. Phillips is concerned about.
I don't have an attorney, okay, Your Honor. And so I just want to make sure that I'm doing everything that I should be doing. And when I do get an attorney, I didn't hurt myself in any way. You know, I don't have an attorney right now. I've been trying to get an attorney. And now one of my biggest questions is, can you help me get an attorney? I went through Northwest Legal Justice, and Eleanor Cotto is through the other one. And so there's conflict of interest, so I can't get one through them. And the other one, Clear, I did an interview with them, and they said my case is too big, that they don't have somebody that can represent me pro bono, and that's my case right now. I just barely got a job, so I mean, I don't have money to get an attorney, and I don't want to hurt myself. And in all the paperwork that I've read, it doesn't say that Eleanor Cotto is. I have to put in an ROI for her, and I don't remember the judge saying that I had to any time sign an ROI for my mental health and my SUD counselors for her. And so that's what, and collateralized to me is Monique is just to call and give her input, and correct me if I'm wrong, but it's just to call and give her input to my counselors. So I don't understand why would her attorney have to have a ROI when the guardian ad litem and Monique both have ROIs now. And I was misunderstanding all eyes and stuff going on, because where I was doing my treatment, there's like 3 different businesses in the one place. It's crazy.
Okay.
But I'm doing everything I'm supposed to be doing. The anger management thing, Eleanor, is the anger right now is they're wanting to charge $600 for an assessment because it's through family court. I don't have the money. I'm trying to get the money together to do that. But Your Honor, the question I had for you for the anger management thing is because it's ordered by the court that I have an assessment done. Okay, my mental health counselor is certified through Washington State. Okay, he's in mental health, and he said he will give. I filed. I got a whole stack of file stuff. I just filed that you haven't had a chance to see yet, but you will before the next court date, I'm sure. But my question is, he's certified. He's my mental health counselor, and he said he will work with me, and he will show proof that he's working with me in my progress with my anger. If I need, I do need anger management. Okay, I'm not gonna say I don't. I do need some anger management, and I'm willing to work on that with my mental health counselor, because I don't have $600 for an assessment and then $35. I'm doing parenting class right now. I'm doing SUV. I'm seeing my mental health counselors. I got all this stuff going on, and I'm willing to work on my anger management. And I just and to ask you if I have his credentials and everything that I had sent you, and showing that he's my mental health counselor, and he said he will have no problem sending over progress and stuff, progress reports to you, to the courts, so you guys can have it. Will you approve that?
Okay, well, let me stop you just for a second here. So I'm at a bit of a loss here because I don't have an order to work from. I don't know what Judge Bassett ordered. It does say something about ROIs, doesn't say to who in the clerk's note. So it seems to me what we probably need to do before I can do anything is to get an order as to what happened with Judge Bassett, so I know what I'm even talking about here.
Yeah.
Well, Your Honor, like I said, everybody was out. I was out ill for a few weeks, and then I was on vacation. So
I don't understand. I didn't know what was on because I don't have an order, and there's so I don't know anything about this case other than it was on for review today or something.
I just want to be able to
Well, hold on a second.
My suggestion to the court, I will get it noted on, and Judge Bassett's presentation docket is Friday at 8:45, correct?
Is that?
Yes.
That appears to be correct.
Okay, so I can't get it on this Friday just because I have a trial, so I don't think I will be available this Friday, but I can put it on for a week from Friday, and I don't have a current address for Mr. Phillips because my last piece of mail was returned.
Yeah, sorry. I'm sorry. I just changed it. I just changed it again. I just moved. It's 327. About that. I was going to call you too. I just changed it today.
Okay. As long as, and so the last piece of mail was returned. So I will get that out, and then we can argue whether I have the ability to have an ROI, because I haven't, if Mr. Phillips filed things with the court, he didn't serve anything on me. My understanding is that this counselor is not state certified in anger management. I don't know who I found it.
He is.
Found out.
Well, hold on.
Oh, sorry.
Hold on. Okay. Why don't we, if you want to, I mean, I could put it on for that docket, but if you want to prepare some orders.
I can do that. In fact, I prepared, the orders is prepared, and I will send it out to everybody today now that I have Mr. Phillips' address. Then we can come back before the court and talk to the court about ROIs. I mean, if the judge said no, she didn't order it, then I will remove that. But it's certainly, it's in my notes. It may not be in the clerk's notes, but if we can put it on a week from Friday, I will get Mr. Phillips a copy of the order as well as Ms. Turnbull, and then we can take it from there.
All right, let's start there. We'll put it on for the 2nd of February at 8:45. And that, sir, that would be a Zoom hearing. So you'll get a copy of the order sent to the address you just gave, and see if that says what you remember it to say, and then that'll get sorted out.
Yeah, I'm not trying to buck the system,
Just listen to me for a second. Okay. So first off, I don't have an ability to give you an attorney. We don't have that available, at least not at this juncture. So again, I would continue. I believe are we still doing are they still doing the Monday things? Or those
just started back up this week. They'll be here next Monday.
Okay.
Yeah.
So if you come here to the courthouse next Monday. They have a lawyer here who may be able to give you some advice.
I've already tried it, and that's the same.
Okay, well, let's just listen to
Okay,
it,
sorry.
sir.
Uh-huh.
Okay, I'm trying to give you some options.
Yeah, okay, all right.
Okay, so if you show up there, maybe they can help you locate someone who can talk to you, if nothing else.
Okay.
So that'll start there.
All right.
When you leave here, I want you to go to the clerk's office and fill out a change of address form so that we have your current address, so we can send you paperwork if we need to.
I just did that.
Just do that.
Yep.
You've already done that?
Yep. And I'm gonna stop buying DVDs, stuff that I filed in the court to you. I'm gonna stop
Hey,
buying,
get
give her a
them-
copy.
Get it to Miss Cotto and get them to Miss Turnbull, so that everybody's got the same
Okay.
stuff.
Okay.
And then once you come back next Friday in front of Judge Bassett, you can ask the questions about whatever she's ordered, and I don't know what that is because I don't have that in front of me, as to what would qualify. And depending, I don't know what your mental health counselor's qualifications are. If they qualify, that may be fine. It may not be.
Okay.
Okay. So at this point, the next hearing is going to be next Friday, the 2nd, 8:45 in the morning, and it's a Zoom hearing. And if you go to our website, it'll be Judge Bassett's presentation docket.
Okay.
Okay.
I just come here. I just come here for it because.
Okay. You can come and use this. You can come and use the Zoom booth. That's fine.
And Judge Bashor, will you remind Mr. Phillips to make sure he gives me copies of anything he files?
Yeah. He just said he's going to do that. So
Okay,
anything.
and I'll have a copy of the order, which I will give him right then, and then I will scan and email it to Mr. Turnbull also.
Okay. So anything that you file with the court, you need to get to Ms. Turnbull and to Ms. Cotto.
Okay.
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 All right. So we'll come back in front of Judge Bassett on Friday, and then if she wants to set a hearing after that, that's fine. If not, somebody will note it back on.
Okay. In order for because I'm doing most of, except for the anger management, it's like I hit a wall there, because like I said, I don't have the money. But in order for me to have a visit with my daughter, over the phone, but I have no problem paying $25 an hour for a visitation specialist. But I haven't seen her in a year, Your Honor. You know what I mean? And I've had a couple relapses in the last 5 months, but I've been clean now for like 2.5 months, and I've been doing my SUD. I've had clean UAs.
Okay. I don't even know if there's a parenting plan in here.
There is a parenting plan. And at this point, we're asking that it says no visits until he does a number of things, and he hasn't completed any of those things.
Yes.
That parenting plan was entered back in November. And so at this point, I would suggest to the court that let's get the order entered, and then Mr. Phillips can renote his, or Judge Bassett can make a decision as to whether or not there needs to be another hearing. There'll probably be another review, but.
Hey, you just said I didn't complete anything in that parenting plan. I've completed most everything in that that plan except for
well, that's not before me today.
Okay,
so,
I was just don't understand why she's saying that. I've been in SUD.
well,
all my stuff.
Hold on. You've done
Yeah.
I can see you've done some stuff. You filed some things. You've done some evaluations. So that's in the file. Not making any decisions today.
Yeah.
Okay. So next Friday, Judge Bassett, you talk about all these concerns about the order. She'll get that entered, and I'll know what she's ordering and what we're working with.
All right.
Okay.
All right.
All right. So next Friday, 8:45.
All right.
That matters.
Thank
Good
you.
afternoon, Your
You're
Honor.
welcome. Good afternoon. And I had a couple of emails that came in late today that had to do.
Yeah, Your Honor, you can disregard. I was looking at a docket that was, I guess, older, and it was subsequently amended. So I was worried that the court wasn't prepared for today's hearing, but it looks like it eventually got on.
So we just have one motion today, correct?
Yes, correct.
All right, then, yeah, I prepared for that. So go ahead.
Thank you, Your Honor. For the record, Megan Gilmore on behalf of the petitioner and moving party, namely Dustin Kent. This matter is before the court on my client's motion to modify the temporary order. A temporary parenting plan was entered in December of 2020 that provided a named mother as custodian and provided my client weekend visitation. The guardian ad litem, Mallory Smith, has provided and filed 3 separate subsequent reports in this case, the last being in November of 2022, where she recommended that my client should be primary parent and the children should be immediately transferred to my client, I believe, over the winter break holiday. The court later denied our motion to adopt.
Hold on 1 sec. I'm getting a lot of feedback from somewhere. Ms. Jeffers, I might
Is
be
it-
from your mic. If I can have you mute until we're ready for.
Absolutely.
Okay, thank you. Go ahead.
Thank you. The court later denied our motion to adopt the GAL's recommendations. My understanding mainly based on the time associated to trial. There was just shortly a few months until we were supposed to go to trial in May of 2023, and the court wanted to allow mother to cross-examine witnesses pursuant to the investigation. However, as the court can see from the record, this matter has been struck I think at least 3 or 4 times. It was struck in May, and it was just recently struck in January of 2024 due to the court's unavailability to have afforded trial. In the meantime, the children continue to struggle under the current residential schedule. We bring this motion out of safety concerns, immediate safety concerns for the children, given mother's recent incident with law enforcement. We attached that police report that really speaks for itself and is highly concerning. As detailed within that police report, the law enforcement was dispatched after multiple reports of gunfire on January 1st in the early morning hours. The police report indicates that all witness accounts were consistent, stating that the victim got out of the vehicle to ask respondent of this matter to move her vehicle out of the blocked roadway. Respondent threw the victim to the ground, placed her knee on the victim's neck, pulled out a knife, and told the victim that she would end her life. This is the mother of this matter and the primary parent of these children. When the victim's boyfriend tried to stop the assault, respondent's boyfriend, Max Myers, punched the victim's boyfriend in the face, chipping his tooth. Respondent took the victim's gun and gave it to her boyfriend, who then refused to return it to the victim. The victim's boyfriend reports that he thought that Max Myers was the person shooting the gun. It is undisputed the respondent's 14-year-old daughter was with respondent while the assault occurred. Respondent doesn't deny that the incident occurred. She admits to having several physical altercations in front of her 14-year-old child, but claims that she's the victim. Respondent also doesn't deny threatening the victim with a deadly weapon or threatening to end this person's life. All evidence before the court shows that respondent is clearly the perpetrator of violence, not the victim. Respondent didn't call law enforcement. She fled the scene and was located by law enforcement speeding away. This isn't the behavior of a victim, but rather a suspect. Respondent has a history, as explained with my client, of meltdowns, domestic violence, and threatening herself in front of the children. Respondent puts the children in dangerous situations and admits to even getting recently into a motor vehicle accident. As explained within my client's declaration, it's my client's understanding that respondent was doing cookies in a vehicle. The vehicle lost control, flipped, and the children were not in safety belts. The children have repeatedly reported to the guardian ad litem as well as witnesses that they are desperately wanting to live with my client. This isn't due to any sort of manipulation.
Your Honor, I'm going to object to use of child hearsay, which almost all of this argument is.
All right. I mean, everything in the police report's hearsay at this point. So, what are? I mean, I've got declarations from him and her. So I guess I'm trying to read through this and figure out what I can consider.
That's correct, Your Honor. But specifically, yes, you're correct. It's hearsay. But with regard to what the children say, I did refer to a previous order. We've disputed this issue many times as far as the validity of statements attributed to them. So at this point, I'd just like to make it clear that I'd ask the court not to consider any statements attributed to the children.
I mean, citing the guardian ad litem recommendation as well as the investigation. The court appoints these individuals to get, frankly, hearsay of children, get hearsay of other individuals, and come up with a recommendation that's in the best interest of the children. The court has wide latitude to consider hearsay information as you do every day on the docket, again, with the interest of ensuring a parenting plan that's in the best interest of the children.
Well, the child hearsay and regular hearsay is still evidence. There's still evidence rules in family law. It's got nothing to do with, I mean, unless there's an exception.
We can move on. We have concerns that mother continues to ostracize the older child, particularly mistreating her because of the guardian ad litem investigation and her reports to the guardian ad litem. The children continue to live in a recreational trailer that is not suitable for permanent housing. Respondent has every ability to rent alternative housing through her own income, through the income of her long-term boyfriend, as well as the spousal support of my client. Respondent simply chooses to remain in her current situation, which again is not suitable for the children because that's where her boyfriend lives. Respondent attempts to make copy and paste allegations against my client, which have been fully investigated through the 3 reports of the guardian ad litem. The guardian ad litem has made no findings of domestic violence or substance abuse on the part of my client. My client presents no threats to these children as contained within the report, and frankly, the recommendation that the children should live with my client. We ask the court to modify the parenting plan immediately, as it's not in the best interest of the children, and they shouldn't be subject to these conditions and frankly mistreatment while we move forward and potentially go to trial in May. But frankly, I don't know the likelihood of that as well. We explained in our declaration that we were before the court on mother's motion to bifurcate the trial. However, she rescinded that motion when Judge Fassett had ordered the parenting plan to be addressed. We have concerns that she did this because she was aware that the incident had happened the day before, and so she didn't want to address the parenting plan and fully flesh out the issues of this case. So ultimately, this is time sensitive. Again, these children are not doing well, and they shouldn't be continue to be subject to this because we have a 4-day trial because mother wants to call 17 witnesses that are frankly not necessary in a 6-year dissolution. So we do ask the court to grant our motion and to modify the parenting plan.
All right, thank you. And Ms. Jeffers?
Thank you, Your Honor. Your Honor, mother requests that the court deny father's request to modify the parenting plan and award attorney fees in this case. I will note for the court, I'm sorry, the declaration was a little bit lengthy, but this is a highly litigated, high conflict case that has been in front of several judges several times at this point. The only new allegation that father puts forward is a police report that he submitted as his request for the change. I'll also just put on the record that I'm going to object to the declaration of Andrea Koenig. My client didn't have any opportunity to respond to that, and this person is completely unknown to my client. So I will put that on the record. I will submit to the court that father has a history of repeatedly pressuring the children to say things he believes will benefit him in this case and uses them primarily to gather information about mother. The court previously found on multiple occasions that the children's statements are not credible. Father lies repeatedly in his declaration. He says, and counsel just said this, he says that this case was not called ready for trial because the incident that was the subject of the police report happened the day before. The incident, Your Honor, on the police report is New Year's Eve. This trial setting was stricken, and this is an odyssey, on December 27th. So at the time that this trial was stricken, this incident had never taken place. Yet father lies to the court and makes it seem like, oh no, mom didn't want to go to the court. I will put it on the record that mother is open to binding arbitration at any point, and that has been made clear to all parties. Father has a history of DV, alcohol abuse, and mental illness. He's currently on deferred prosecution for DV, where he had to acknowledge both DV and mental health issues. As a brief background to this case, mother fled the family home with the children after DV perpetrated against her by father. This is undisputed. You know, indeed, even in the 2017 police report filed by father, it shows that the oldest daughter attempted to defend mother from father as father forcibly took a baby from mother's arms, and that father hit mother so hard she was thrown into another room and to the ground. Certainly, we submit to the court that it's an ongoing pattern of behavior. Father simply called the police because he didn't want to be arrested. And father continues to display domestic violence tendencies that he exhibited during the marriage, including animal abuse, which is documented in the latest GAL report, alcohol abuse, that Facebook picture. There is a 12-pack of twisted tea and a half-drinking bottle of whiskey, very large bottle, behind those children and within reach of those children. He also continues to stalk mother. This includes constantly drilling the children to gather information about mother, reaching out to strangers to see if he can get them to say bad things about mother. And we submitted those text messages that are from father. intimidation tactics at child exchanges, and constantly testing the boundaries of the current protection order. Father has flat out refused to obey orders of this court in the past. I mean, he says things like, oh, I've paid so much in support. He means child support only, Your Honor. The only reason he wasn't ordered to pay spousal support was because he was responsible to pay the mortgage, and he promptly stopped paying. Father, again, he is still drinking. He doesn't deny that. And most serious of all, Your Honor, is a concern that Father arranged for this altercation with Mother on New Year's Eve. I mean, at first glance, it would appear that the perpetrators were just angry drunks who were armed, but that doesn't explain why Father had knowledge of the event as it was happening and reported it to police. These are people that my client doesn't know. These are people that Father says he does not know, yet he's got intimate knowledge of this when those are the only people present. Certainly, that is very suspicious. And I don't believe that Father realized that they were going to disclose that he was the reporting party in the police report. Mother didn't know these people. It's obvious that Father did, and that would explain their extremely aggressive behavior that appeared deliberate. Mother did nothing other than be a victim of a crime. Nobody in Mother's party was drinking. And it's funny how in the declaration, Father twists around the circumstances here. Nobody in Mother's party was drinking. The police did safety checks in the cars. There were no firearms owned by Mother or anybody in her party, no drugs, no alcohol. And it's mentioned multiple times that the people in the other car were intoxicated. And looking directly at the police report, Father in his declaration says the other parties didn't want to be a victim. Actually, the people listed in the police report as the victims that refused to file charges are the people that were in Mother's party, not the other way around. Indeed, the only written statement submitted said that things got out of control when a woman in the Dodge truck threatened a gun. That is not my client. That is the woman that pulled up behind them, was intoxicated, armed, and extremely aggressive. Father completely, he just makes up facts. He says that, oh, there was some car accident. However, Father wasn't there. He doesn't know that to be true. Something about them hitting a tree and things like that. It just didn't happen. Mother did nothing wrong in either of these cases. She was attacked by a woman, when she asked them to wait a few minutes. And that's something that seems to indicate that the woman intended to attack Mother before they even encountered each other. All Mother did was defend herself. She even kept the woman just on the ground until she calmed down. She denies any threats to kill. And her boyfriend, quite frankly, was right to take a gun away from this woman who was making it clear that they intended to use it. Both the boyfriend, Father says, oh, they didn't contact the police. That's not true. The boyfriend made it clear that he was going to be turning the firearm over to police as soon as they were back in reception. He called police himself. That was the right thing to do. There were never any gunshots. It was an old truck that was backfired. And being a victim of a random crime is not a basis to change the parenting plan. And again, going back to this horrific four-wheeling accident where the kids were with Mother, Father completely made this story up. He has no knowledge of it. One day in May, they got a wheel stuck and tilted a little bit. When they went four-wheeling, the kids were strapped in. 7 weeks later, Father took the child to a chiropractor, not a doctor, claiming the injury to the child was from this May accident. In reality, the child fell out of a top bunk at Father's home, and likely Father lied because he thought that it could be used against him in court. The court has already said a change to the parenting plan will only happen at trial, yet here we are again. And Mother is requesting attorney fees. Mother denies any abuse of the children. CPS has cleared her every time Father is called. The GAL has cleared her of all of father's allegations. Mother's living situation has been cleared by the court during a full evidentiary hearing. Mother's situation is temporary until she can obtain her equity in the family home. And children are thriving in her care, acknowledged by teachers, neighbors, several people in prior pleadings. Ironically, the family home is for sale. Father intends to then live in a trailer himself, something he doesn't deny. Mother staying in Toutle, where the kids have gone to school. Neither child ever went to Kelso School District. Father doesn't know what school district he will live in once the home sells. It is best to keep in their best interest to keep them in their same school. One child has special needs. They've been working with her for years. Father transporting the kids every day is not good for the kids. It's too much time in the car. And as it stands now, father hasn't been showing up to events because of the long drive. Mother requests court deny the motion and award attorney fees. And if father wants to resolve this case for good, we are willing to go to binding arbitration immediately. Thank you, Your Honor.
All right, Ms. Gilmore.
Thank you. Just briefly, I think it's absurd to allege that my client somehow manufactured the situation that happened in January. He testifies to this court that he doesn't know who these individuals are. The report specifically states that Max Myers and Heather Kent are the suspects, and that this Alexis Pucci is the victim. My client didn't contact law enforcement, again, doesn't know these individuals, didn't know this incident even occurred until I think the day later. And again, this is Cowlitz County. It's a small county, which information, especially particularly relating to deadly weapons and firing guns, does get around. There's no evidence that my client is ever involved with children. The court has never made any sort of findings that the children's statements aren't credible. My client, again, when it comes to this incident, information came to him over the police scanner. So again, to claim that under the microscope of this extremely intense litigation, that she didn't do this incident, and despite the fact that, again, this is very concerning, I'm concerned that what her behavior will be moving forward. She has a history of issues with mental health. I don't think that the guardian litem has cleared her, frankly, of anything. And again, the guardian litem had concerns about the housing as well. So where we're at this point is that my client is simply trying to protect the children. He doesn't believe they're doing well from his own experience and his personal knowledge of the children and their prior statements. The guardian litem recommended that this transfer happen. And frankly, procedurally is the only reason that we haven't been before the court to make a final ruling on this case. I don't believe that there's any court orders prohibiting my client from bringing motions, again, over this 4-year litigation as issues come arise. The court had information in January 2023 with understanding that we'd be going to trial in May, but I don't think that anything prohibited him from bringing additional motions when, again, from the face of this police report, it's extremely concerning mother's behavior, her anger, and frankly, I question mental health. The report speaks for itself. I think that she is the suspect. She is the perpetrator of violence, which has been historical throughout the marriage. My client, the guardian litem, again, did an extensive investigation. She made no limiting factors for domestic violence. She had no concerns about substance abuse. This alleged incident that mother continues to bring up was from date of separation in July of 2020, which is, we're going on 4 years now, and again, has been investigated by the GAL. My client completed DB treatment with bullying recommendations. So we are asking the court to modify the parenting plan based on the current facts. I also have the concern of the fact that if we do move forward with trial in May, the guardian litem report is now going to be, at this point, 14 months old. It will be roughly 1.5 years old, and the court will need new information, and particularly as facts continue to advance. This isn't a case that's sitting idly, as again, mother continues to have issue after issue in her home. So I asked the court that we potentially need to consider reappointing a guardian ad litem. I did serve Ms. Smith with the motion today. I don't see that she is on the docket. I think that she was on the trial assignment docket previously. I understand that I don't believe that she's currently on the list, and I think that she has taken on a new job. But I do think that given the ongoing facts of this case, that it may be appropriate, especially particularly in light of trial, the trial judge will want an updated report.
And Your Honor, I'll just object to any request for GAL. It was not part of the motion. And if it becomes a motion, then I will address it at that point. Thank you.
All right. Looking at the, first off, it's, reading the police report, it's not admissible as evidence as it sits. It's hearsay of hearsay. I mean, his declaration appears to be drawn mostly from that. Obviously, there are some concerning things in that police report. But having read hundreds of police reports in my career, they give you what information that the police officer got from whatever people they talked to at the time. And it's not clear reading through this even who all, it looked like you talked to everybody at some point, but they didn't pursue any kind of law enforcement action against anybody in the case, which generally speaking, they will do so if there is a concern. Hold on just a second, I'm getting some feedback here. So, I mean, it's a concerning incident, obviously, but I'm not going to make a change at this time. This is currently set in May, is that right? You said?
Yes.
Well, it probably could be set sooner if you were to do it over a course of a couple of weeks, or if you wanted to bifurcate it. But it's been going on a long time. It probably, I mean, I think there's an argument that having some sort of update with what appears to be a lot of activity happening is probably not inappropriate. I'm not going to make that order today, although certainly would consider it if it were brought. So I'm going to deny the motion this time. I'm not going to order fees. I don't have a basis for that at this juncture.
Thank you, Your Honor. Thank you, counsel.
Does the court want to enter a bench order, or do you want to set it on for presentation?
I can just do a bench order denying the motion.